Hello. Okay, we're back with section 3. This is title and escrow. This is where we choose the escrow company, escrow and title company here in Arizona. Typically, the escrow company and the title company are one and the same, although the title insurance may be issued by another company. The escrow, like I said, escrow and title company are typically the same. This contract shall be used as escrow instructions. Escrow instructions are basically tell the escrow company how to handle everything and what to do. The escrow company employed by the parties to carry out the terms of this contract shall be, and this is where we choose, title investing. A buyer will take title as determined before close of escrow. If the buyer is married and intends to take title as his or her sole and separate property, a disclaimer deed may be required. Taking title may have significant legal, estate planning, and tax consequences. The buyer should obtain independent legal and tax advice. All right. Title commitment and title insurance. Escrow company is hereby instructed to obtain and deliver to buyer and seller directly, addressed pursuant to 8S and 9C or as otherwise provided, a commitment for title insurance together with completed and legible copies of all documents that will remain as exemptions to buyer's policy of title insurance or the title commitment, including but not limited to conditions, covenants, and restrictions, also called CC&Rs, deed restrictions, and easements. Buyer shall have 5 days after receipt of the title commitment and after receipt of notice of any subsequent exemptions to provide notice to the seller of any items disapproved. The seller shall convey title by warranty deed, subject to existing taxes, assessments, covenants, conditions, and restrictions, rights of way, easements, and all other matters of record. Buyer shall be provided at seller's expense an American Land Title Association or ALTA homeowner's title insurance policy, or if not available, a standard owner's title insurance policy showing title vested in buyer. Buyer may acquire extended coverage at buyer's own additional expense. If applicable, buyer shall pay the cost of obtaining the ALTA lender's title insurance policy. Okay, I'll have a video done specifically by an escrow officer explaining some of this stuff, but the owner provides a homeowner's title insurance policy that protects the homeowner from any clouds on title, let's say. And then if typically the buyer's lender will require the buyer to purchase an ALTA lender title insurance policy, which actually insures the lender against clouds on the title. Additional instructions. Escrow company shall promptly furnish notice of pending sale that contains the name, address of the buyer to any homeowners association in which the premises are located. If escrow company is also acting as a title agency, but is not the title insurer issuing title insurance policy, escrow company shall deliver to buyer and seller upon deposit of funds a closing protection letter from the title insurer indemnifying buyer and seller for any losses due to fraudulent acts or breach of escrow instructions by escrow company. All documents necessary to close the transaction shall be executed promptly by the seller and buyer in the standard form used by escrow company. Escrow company shall modify such documents to the extent necessary to be consistent with this contract. Escrow company fees, unless otherwise stated herein, shall be allocated equally between seller and buyer. Escrow company shall send to all parties and broker copies of all notices and communications directed to seller, buyer, and brokers. Escrow company shall provide broker or brokers access to escrowed materials and information regarding the escrow. If an affidavit of disclosure is provided, escrow company shall record the affidavit at close of escrow. Tax prorations. Real property taxes payable by the seller shall be prorated to close of escrow based on the latest tax information available. Release of earnest money. In the event of a dispute between the buyer and seller regarding any earnest money deposited with the escrow company, buyer and seller shall authorize escrow company to release the earnest money pursuant to the terms and conditions of this contract in its sole and absolute discretion. Buyer and seller agree to hold harmless and indemnify escrow company against any claim, action, or lawsuit of any kind, and from any loss, judgment, or expense, including costs and attorney fees arising from any related in any way to the release of the earnest money. Proration of assessments and fees. All assessments and fees that are not a lien as of the close of escrow, including homeowners association fees, rents, irrigation fees, and, if assumed, insurance premiums, interest on assessments, interest on encumbrances, and service contracts shall be prorated as of the close of escrow, or we could put any other date in here. Assessment liens. The amount of any assessment lien or bond, including those charged by special taxing districts such as Community Facilities District or CFD, shall be prorated as of close of escrow. That wraps up section 3. On to section 4.